right, you're welcome to Good Afternoon, Ghana. So we're continuing with the analysis of all updates and breaking stories that's going on in the country. And the one that we all seem to be interested in now is the outcome of the court ruling concerning the Assin North constituency member of parliament, Jason Atukwesing. So the issue is about what his citizenship really is about. Is he Ghanaian? He's Canadian. Is he holding both? And information we have is that he has actually released one of them, or has denounced one of them, which is the Canadian citizenship. But before that, he was taken up on in courts, and he is now dealing with the issue. So let's see how Atukwesing is going to handle this. But some lawyers are also telling us that, well, the substantive matter itself is yet to be heard. We are also yet to find out some details about that, what that really means. On the political side, what's the effect with the political parties, or what's the effect it's going to have on political parties as far as his position as an MP is concerned? When we have more time, we'll also spend on the mining sector. The Minister for Water Resources, Cecilia Benadapa, has already briefed the press and told us how dire the situation has gotten, where it's becoming almost difficult to have water resources to be, get us potable water, because all our water bodies have actually been rendered almost unusable by illegal mining activities. If we have time, we'll get into it and also see how far we can go with that. This is Good Afternoon, Ghana. Let's take a break. We'll be back. Welcome back. This afternoon, we'll be doing the discussion with Jonathan Assin, who is a political analyst, and also respecting Abraham Amalaba, who is a legal practitioner, member of the NDC legal team, and also Justice Abdullahi, who is a legal practitioner. He will also join us via Zoom. Let's start off with Jonathan Assin, who is already joined us. Jonathan, you're welcome. Good afternoon to you. So, we've had, different issues of Atukwesing's matter in different courts, high courts, appeal courts, the Supreme Court, and all. What is this all telling you? Because we've already had complaints from his legal team that the court processes are not fair to them. How is this communicating to you? Hello, Jonathan.
Good afternoon.
Good afternoon. Well, good. I can hear you now. Yeah. So I was asking, yes, how all the back and forth concerning Atukwesing's case and now the ruling of the Supreme Court, what's communicating to you politically in your capacity as a political analyst?
Well, let me say good afternoon to your viewers and good afternoon to you as well. The point is that the aim of this particular case, especially the complainant, as it were, we know those who are behind the scenes, is to deny the MP of that particular position. But the ultimate aim is to ensure that they shift the power, the power of a hung parliament, as it were, to a position where there will be that slim majority, as it were. So the back and forth of the whole thing, that is the main, the thrust of the whole issue. But as to whether, the complainant and the team will be able to do so, only time will tell. But politically, I think that the terrain is the tension is a bit high in the system, and the communication that we are having, more or less, is indicative of the fact that, well, this time around, the process itself has not yet ended. And the person is told that you cannot hold yourself as an MP. You may not be able to perform those functions until the substantive issue is dealt with. So until the substantive issue is dealt with, are we suggesting that the people of Assin North should not have representation in Parliament? Is it any different from Techiman South, in which the High Court virtually said that they cannot deny the people of that representation? And that one is just counting error. But up to now, we are yet to see substantially any progress or significantly any progress. Now, all these, machinations, manipulations, outmaneuvering your opponent, and so on and so forth, will go as far as fueling that perception that the national security minister has intimated to all of us. And it's not as if it's the national security. It is a perception out there in this country, and itself is a security issue for all of us.
Right.
So in general terms, what has happened now, I don't know how the lawyers may have their word. I don't know how we intend to go about it in terms of creating a vacuum. You've not dealt with a substantive case. Can you then tell the informed parliament that this person can no longer hold himself as such, and for which reason there is the need for them to announce for a by-election to be conducted, and will the same person not qualify to contest? So the permutations are too many. Probably in the course of the dialogue or the question and answer session, then we may come up with other ideas.
We'll ask the lawyers as and when they join us on those legal questions that are coming up. Let's stay in Parliament. When you say that they actually are making sure, that is from the majority side, trying to create a case of simple majority simple majority. But I mean, the majority side currently have two major issues of some of its members not coming to Parliament. One of whom we're told is in critical condition, as in not being well. And we also have Adrasafo, which openly has political dispute with her own party, and so it's not showing up in the House. If really the reason was just to create a simple majority in Parliament, why would the majority go on this tangent? Because they already have at least these two major cases on the floor that is affecting the numbers of the majority in the House.
Well, some analysts have also argued that the main target is Adrasafo, and that they will find a way or means, I don't want to prejudice it, more or less a means of ensuring that Canada, Japan, and Henry Cote, are left on the hook. Parliament, they say, is a master of their own rules. So that is the view of some people as far as the politicking is concerned. So if it is Adrasafo, I am very much informed that if you look at the trend of voting as far as the Bamiko Abenya is concerned, then it means that the MPP has an edge. Should there be the need for a by-election, or should the process go to a close and we are told that the fine lady is guilty and that the seat is declared vacant because of the numbers that the lady had in the previous elections? But the dynamics have changed, as it were. In 2020, the economic condition of this country was by far different from 2022. And so if we are to do realistic analysis and use the economy or the economic condition that Ghanaians find themselves as the yardstick, as the basis for people to decide who they should vote for, then I think that the MPP will have more more issues to handle. And then the point to some noise in the background.
Okay, I'm
The
having
point,
producers, if you can check this for me, I'm having interference in the feed. Kindly check that for me. Okay, you can go ahead, please.
so that is exactly the point. But you look at Mr. Kwesen's issue. Of course, it started long before the Adwoa Safo issue came up, and they used that, as it were, as a tool before the e-levy issues. So that one is known, and they were able to succeed to do that. But of course, that issue too has been sent to Supreme Court, and probably the ruling, I don't know when they intend to look into that particular issue. But I'll be very much glad if the way and manner they speedily conducted Justice Abdullah's case that he sent to them, they will be able to do so with the issues that have been sent to the Supreme Court by the minority leader and Mr. Blackwell and so on and so forth. So that's for the political maneuvering. You just cannot use one particular tool to deal with that. You may have to do this, manipulate here, and so on and so forth. So the game is that reduce the number of your opponent so that you'll be able to pass your bills with ease. And don't forget that because you have a substantial number of ministers coming from parliament, at any point in time that they go out doing government business, they are out of parliament. And with this slim majority, it really affects government business. So if they're able to reduce the number by adding one to theirs, that is a suggestion or hypothesis, then obviously they will be in a better state, as it were, to conduct government business in parliament. So that is the ultimate game.
So we have been joined by Justice Abdullah. He's a private legal practitioner. Justice, thank you for your time. Good afternoon to you. So there's been the questions of, okay, why do we want to prevent Judge Kwesi to hold himself as a member of parliament when the substantive case is not being heard? How do you interpret it for we, the laymen, to understand what that legal action that's been triggered by the court means?
At this moment, I must admit that it's difficult for me to prefer any better judgment on the decision by the Supreme Court. Ostensibly because, of course, we do not have the reasoning before us.
Right.
And so it deprives us of having the ability to make constructive analysis and indeed propositions of what has happened. But having said that, I think it's a very difficult issue when an injunction is placed on a public officer of this nature, depriving him of representing his people. I think it's a very disturbing and worrying phenomenon. But because it's coming from the Supreme Court, it makes it quite difficult to be able to, and without the decision, the full judgment before us, it's quite difficult to be able to, go into their minds and understand the basis for doing that. Because typically, usually, what you would find is that for public holders like this, it's very difficult to get an injunction on them because of this a peculiar role they play. First representing his people and serving as a check and balance on the executive, and in fact, the role of a member of parliament is not that typical role that you find across the street. It's a very significant role because of the peculiar nature of that office. And so for a Supreme Court to say that a particular member of parliament should be injuncted until an issue brought against him is heard, it's a very difficult thing that I can justify at this moment without having the benefit of the decision before me.
But references have been made to the Tsuchiman South constituency, which had a similar issue where, well, the MP, if you actually prevented him from holding himself as an MP would have made the constituency an orphan one. And so the court did not allow that. Is it difficult for the Supreme Court to make references to the, case references such that they will form as a precedent, which is, of course, a practice in court?
To be fair, there are differences in the two scenarios.
Right.
And so, first of all, no two scenarios are the same. But second, in particular, in this instance, what we find is that with Kwesi, Mr. Kwesi's case,
right,
he has lost the legitimacy from the High Court all the way to the Court of Appeal. And so there's really nothing holding him as a member of Parliament. So that is what makes his case relatively different and unique.
Right.
He has almost nothing holding him or allowing him or even holding him as a member of Parliament. First of all, the High Court has dismissed his, literally throwing him out. Court of Appeal, similar. Almost all his applications before the Supreme Court have been literally thrown out. And so, in substance, there's nothing that holds him that should allow for him to be able to practice from his office. But that notwithstanding, because there's still a tendency of an application, I think that goes to the root of the whole issue, which affects the appeal. I would have been a bit hesitant in throwing him out, because literally what it means is that his entire constituency have been left not only to be orphans, but to be left uncatered for. They have no representation in Parliament. They have no voting right in Parliament. They have no mouthpiece in Parliament, and they literally have nothing. It means literally that government business can go on without anybody advocating for these persons. And that is very dangerous.
Yeah, that has been the concerns that's coming out now. You call that dangerous. Why do you describe it as dangerous?
Because, like I've said, I mean, for a constituency to be left without a representation, you see, this is different from Seoul, that part of Volta region, where, in a way, there is still somebody. They fall within two different regions or two different districts. So somehow there is an MP for such an area, or you can also say differentiate that area also from this place, because it also has it was a constitutional blunder that was occasioned on all of us by Parliament of all people, by Parliament of all offices or institutions. But this one is a constituency that has literally voted for a member of Parliament to represent them, so that he can advance the course of their development and speak their minds, not only to government but to authority. But these people, by virtue of this judgment, decision of the Supreme Court, have been deprived of this entire representational of capacity that they would have had in their member of Parliament. They are deprived of their views on government policies and programs. They are deprived of the advocacy for their development. They are literally being deprived of everything that a member of Parliament, either in principle or in concrete terms, would have been able to do for them. And that is why it is very dangerous. And this is the most dangerous part. We do not even know when and how. It could as well end up being the case of George Amon, which took the next 4 years to be resolved. The next 4 good years. So you would never have a member of Parliament, at least for the next 3 years in this particular case. And this constituency will still exist. It will never be wiped off the face of Ghana, but without any representation for the next 3 years. And that's what makes it even more dangerous.
I mean, you said that you described the case of the SAL as a constitutional blunder. Can this Supreme Court ruling be, called a case of constitutional deliberate mistake?
For now, as I've said, it will be very difficult for us to be able to question the rationale behind the Supreme Court's decision, because none of us has the reasoning, the full judgment before us. So once we have it, then of course we can make constructive criticism of it.
Right. A member of the NDC legal team, lawyer Abraham Amaliba, has also joined us via Zoom. Thank you for joining us, lawyer. Welcome to Good Afternoon, Ghana. You say that the legal procedures have not been very fair to you. In what sense are you saying this? Because we've gone through high courts, we've gone through the appeal courts, and the Supreme Court also holding up with the 5-2 ruling today. Why do you say they've not been fair to you? Hello, Lawyer Malabar, can you hear me?
Can you hear me?
Yes, I can hear you now.
Can you hear me?
I can hear you, please. I can hear you now, yeah.
Now, in this...
Okay. All right, we're obviously having challenges with Amalaba's, network, and we just hope that it can be restored as soon as possible. We're discussing the updates that came from the court on Jechikwe in the MP for Assin North. All right, lawyer, go ahead. I'm so sorry. I'm so sorry. Okay, producers will work around that to restore his network so that we can have a fair conversation on the updates. Lord Abdullahi, we do not know we do not know when the reasoning for this ruling when it will come out, and we're also waiting for the substantive case to be heard. What is involved in the substantive case? What makes the difference with this one and what the substantive case is? Hello, Lawyer Abdullahi.
Oh, yes. Sorry, I didn't hear.
Okay, so
I thought you were referring to Dr.
No, his network is not
helping
helping us.
to Amaliba.
No, I'm referring to you now. His network isn't really.
Can you hear me?
Yes, I can hear you. I can hear you. Lawyer Amaliba, are you back?
You can hear me now?
Yes, I can hear you now.
I'm here.
I can hear you now. All right. So for your question, I was asking you why you say the court processes have not been fair to you. Okay. I seem to be struggling with Lawyer Maliba. Let's move to Abdullahi. Justice, are you there?
Yes, I'm here.
Okay, good. Okay, if it's possible, producers, let's have Lawyer Maliba via phone. Justice Abdullahi, so I was asking, we're saying that we're now waiting for the substantive case to be heard. And I'm asking, just for clarity, what is the difference between what happened in court today and what is to be heard in the substantive case?
Yeah, my understanding was that the appeal was struck out. The appeal itself, the substantive appeal, was struck out for what of prosecution because they could not meet the timelines within which to file their statement of case, among other things. This is my understanding of what happened with the substantive case, and I understand that the file for a releasement of it, which was granted, I stand corrected too on this. And so what it means is that still pens, if my information is correct. Now, if that still pens, then notwithstanding all that has happened, everything can be reversed if the Court of Appeal decides otherwise. I stand corrected on these set of facts too.
And is this reversal possible in real terms, as we're talking about concerning the current situation? Do you think this reverse is possible?
That's exactly why I mentioned the case of George Amo. That was an MP for Iowa West Wogon, that's Legal and His Environment. If you remember, I think back then in the year 2000, if I'm accurate, I think the year 2000, he wanted to become, 2000 or 1996, he wanted to become the MP of that area. And we had to spend well over the entire 4 years challenging the legitimacy or otherwise of the MP that was declared, the NDC MP that was declared a member of parliament. By the time the final verdict was out, the entire 4 years had been spent. And so even though he was declared the MP, duly elected, he never occupied a single day in office and never enjoyed his membership of the House of Parliament. And my fears are that this could potentially have the same effect. In fact, if you listen to what the Attorney General said, i.e., the fact that the Electoral Commission could as well go ahead and declare the seat vacant, that is instructive in this particular case to know that it tells you that even though there's no clear pronouncement by any of the courts to the effect that the seat is vacant, but because of the injunction that has been placed on him, there will neither be a member of parliament representing that constituency, nor even a by-election for that matter. And so we just be sitting there playing the wait and see attitude, and which can take quite some time to happen if things are not fast-tracked.
Well, Lawyer Maliba, we're told, has joined us via phone. Lawyer, can you hear me now? Lawyer
Hello.
Abraham
I am
Amaliba.
still with you, though.
I can hear you now.
Okay. So I was asking that you earlier on said that you were accusing the legal processes as not being fair to you. If you can explain that for us to understand where the NDC is coming from.
Well, we have indicated that what the petitioner engaged in is what amounts to forum shopping, because we were in the Cape Coast High Court when I, then lawyer for the MP, no, he's still a member of parliament anyway. He's only been injuncted from going to parliament. He's still a member of parliament. When I raised the issue of Article 94(2)A and said that this must be remitted to the Supreme Court for interpretation, lawyers for the petitioner, Frank Davids, opposed me, and the judge agreed with him, and they went ahead and gave a ruling. Today, the same Frank Davids filed this current writ at the Supreme Court, asking the Supreme Court to interpret Article 94(2)A. That we think amounts to an abuse of the court process. But in granting this application for injunction, we thought that what is paramount and for the court to consider was what is the irreparable damage caused by the MP if he continues to be in parliament to the people of Assin North. In other words, he has been in parliament for more than 1 year now.
Mm-hmm.
What has happened to that constituency? Are people dying? Are people deprived of drinking good water? Is there anybody there who says that because the MP is in parliament and doing his work in parliament, he, a constituent, cannot go to parliament? What is the irreparable damage?
But the Constitution does not refer to irreparable damage. It says that a person shall not be qualified to be a member of parliament if he, A, owes allegiance to a country other than Ghana, or has been adjudged or otherwise declared.
Are you listening to me? That matter has not been determined. That's why they are there to interpret Article 94(2)A. So what question are you asking me? Are you also falling into that same trap that the man has committed a wrong?
What trap?
So if the substantive matter has not been determined, why are you stopping the people of Assin North from being represented? And that's why I say it's a sad day for our democracy, because already SAL, the people of SAL, are not represented in parliament.
Okay,
How can you say that you are running a democracy when a good number of your people are not represented in parliament? What kind of democracy is that? You can go ahead and ask me your next question.
So your point is you're saying that the substantive issue of the interpretation of clause Article 2A 94(2)A has not been ruled on, and so he cannot be prevented to holding himself as an MP. Is that what you're saying?
What is holding himself as an MP due to that constituency? What does he holding himself and going to parliament and representing the people all this while, these years that he has been there? What negative effect does he have on the people of Assin North for you to want to stop him? I want somebody to answer that question.
You want who to answer that question?
Somebody, anybody who can answer that question.
Do you have plans of, should there be by-elections? Do you have plans of fielding him again?
That is a political decision that will be taken by the leadership of the party. But if you ask me whether he's qualified to contest, yes, because the argument of the petitioner, who is an MPP person, is that at the time of nomination, he wasn't qualified. Even though we, on our side, say that that is not what the law says, because if you look at the PNDC law, People Representation Act, the period that you will be deemed to have been qualified to contest is at the time of elections, not at the time of nominations. And come to think of it, who will be denouncing his citizenship of another country just because he wants to go and pick a form? But at the time of elections, when we are at the elections, you must make sure that you denounce your citizenship.
And he had denounced at that time.
He has denounced even the day that you were lining up, you, on the 7th of December, he had already gotten his renunciation certificate. So as we speak, he's not under any disability, even if he was at all, even though I don't agree that he was. Because at the time of elections is what the cutoff point, and not at the time of nomination. They are using Zenator wrongly and applying it on this matter.
Come again on that one. You said they are using a matter of what to apply it on this matter?
The Zenator case. There's a case of Zenator which went to court. And her case was about voter ID cards that she didn't have. It's different from nationality or allegiance to another country. The voter ID card that she didn't have when she was going to contest for NDC primaries, that is different from what we are seeing now. And yet, they are forcefully using that one, applying it to his case, when his case doesn't fall within that.
Did the judge make reference to that case, to the Zenator case?
I'm talking about when this matter started at the High Court.
Okay.
Check the High Court judgment. The High Court judgment that the MPP is all over, saying that the High Court has stripped him of his membership of Parliament. Check that one.
That's what you're referring to.
Yes.
What is next on this? First, respond to this. The 5-2 ruling. How does it? How do you interpret it? Do you think that well, there's hope somewhere? Is it fair? Because consistently you've had the issue of latest rulings from the courts, which comes in the view of unanimous, decisions. Does this 5-2 give you some hope that there is something you can do?
I'm going to disappoint you. I have taken a personal decision not to talk about the Supreme Court any longer. It can be 59-0. I don't care. I'm not talking about them. Your next question is what?
Why? Why is it
Your
so?
next question. Give me a next question.
My next question is why?
Next, go ahead. Go ahead.
Because the Supreme Court still exists.
Talk about it.
Hold on, lawyer. The Supreme Court still exists. And it's making decisions that's affecting you and your party. So why do you decide to stay off things that you're not happy with?
People don't drink alcohol. Why are you going to ask them that they don't drink alcohol? There's alcohol everywhere. People don't drink them. Why are you going to go and ask them? It's my personal decision. What is your problem? Why don't the people are there? They don't get married. Aren't there women around? What's your problem? Go next question.
You're still watching Good Afternoon, Ghana. I'm speaking with lawyer Abraham Amaliba, who is a member of the NDC legal team. I also have Justice Abdullahi with me, and also I have political analyst Jonathan Asante with me. Lawyer Amaliba, let me ask you, are you going to appeal this ruling?
It came around 10-11. We are planning to meet this evening. When we meet, we'll decide the next line of action.
Have your party met yet? Has the legal team met yet?
No. That's what I'm saying. The legal team, I'm the head of that team, and I'm saying that we are convening this evening and to take a decision.
Okay, you're convening this evening. All right. Let me come to Jonathan. Jonathan.
Am I allowed to go?
Hello, Jonathan.
I can hear you now.
Okay, great. What do you make of all that is, what we've discussed, and of course, especially from the quarters of lawyer Abraham Amaliba?
No, you are wanted.
Me, I think that Ghana, we are chasing whirlwind, and a country that is so much indebted, we simply do not care how much we spend and how much the state is likely to expend when it comes to things of that nature. We need to be progressive minded. If this particular personality qualifies to contest, and if you look at the scenario and the situation as it stands now, which is most likely if he contests, is going to win hands down anyway, then why are we just using legal gymnastics, as it were, to create this embarrassing, situation for all of us in this country? Because I just don't get it. If the substantive case is yet to be heard, and you are saying that the person cannot hold himself as a parliamentarian, cannot go and perform that function, I think we need some clarity on this particular issue. And then having listened to Mr. Malaba, it makes it clear to me, and then justice as well, it makes it quite clear to me that that perception of bias in this country is getting more and more fomented by the rulings that keep coming out.
I mean, it's a little surprising, not to cut you, but it's a little surprising that lawyer Amaliba, who is the leader of the NDC's legal team, regardless his political lineage, has decided not to speak on any matter of the Supreme Court, regardless its ruling, whether it's 94-0, that's what he's saying. And also, justice is also finding it difficult to read in between the lines as far as the judgment is concerned, and has expressed worry about the constituents and all that. What does it speak of the Supreme Court? How is it communicating to us and your interpretation as a political analyst?
See thereabout in the Roman Republic, where you will see that the laws of the land were virtually in the heads of those who were ruling, and looking at the crooked nature of your nose, they determined the kind of punishment or the way they should interpret the law, as it were. And these things led to a civil war in that period, because if people then come to the realization that they will never get justice where you go to such places, then obviously, gradually, our nation will be degenerating, because that perception is a security threat. And that is where Mr. Kandapa is coming from. You see, what irreparable damage would his presence in Parliament do to the people of Assin North, to be precise? And if this person, for example, has given reasons to the effect that COVID and other things, we are in this country that our government has been using COVID as the cause of our wars, and then lately Ukraine. So if the person filed the process and COVID in itself intervened in such a way that he could not get it before the nomination, then why are we so fixated on this particular issue? As I said, the ultimate game, the ultimate end is to deprive their main opponent, one particular member, and as it were, to ensure that they have that kind of simple majority and an edge when it comes to parliamentary business. So it is purely political. But if we tend to use the judiciary and we make them become a political tool, that is where it fuels that perception, because it is quite strange that all throughout, the other side has yet to win anything. Is it that they've always been sending bad cases? And Justice was talking about the Assin Teachment South being different. The case, yes, different. No two ways about that. But what the judge tried to suggest is that the people cannot be denied representation, not actually the case. the people cannot be denied representation. In actual fact, it is more or less like throwing away the injunction that was demanded and saying that they ought to be represented. Positive thinking. They ought to be represented. Positive thinking. So if you have such a case, what the precedent, how different is that for the Supreme Court to also say? Besides, what are we talking about? We are talking about somebody who holds allegiance, supposedly, to Canada and being a Ghanaian for that matter. And the process has gone through. And we are not even so clear whether nomination or at the point of election. So I was asking my colleague professor, if after the election he had not won, what would have been the issue now? It would have been much ado about nothing. But because there is an interest, a significant interest for that matter, and we are talking about numbers, that is the more reason why this case is dragging, as is persistent. So for me, it is virtually drawing and fueling that perception of bias as far as the judiciary is concerned. It is fueling it because it is just quite strange that all these years, from the time that the MPP took over, as it were, issues of elections, dispute, petition here and there, have not gone the way of the other side. Not a single one. So that is a bit strange. That is a bit strange. And well, these colleagues who are lawyers will have to feel restrained because you pass a certain comment and then you are dragged to the Judiciary Council. So what are we trying to do to our democracy?
I'm going for a break.
People? Are we trying to terrorize people using the same institution, a public institution that is supposed to protect the integrity and our safety, as it were, in the country? It is virtually becoming a terrorizing people using the same institution. That is not well in order. You see, the judiciary is supposed to protect all of us. Parliament is supposed to represent all of us. The executive is supposed to execute. And we need to see that everybody is doing its part. If there is a security threat, believe you me, my sister, nobody is safe. It doesn't matter whether you are a member of the Supreme Court. Nobody is going to be safe. So let us protect our democracy one way or the other. If just for counting, reasons of counting, the Techiman South issue is still pending, counting, then you are talking about just technicality of either the person filing nomination at the time of election was he or he was not. I think that we need to be progressive-minded, right, as far as this particular issue is concerned.
Right. Let me take a quick breather. I'll be back to wrap up with my guests. Just wrapping up with lawyer Abraham Amaliba, who is the lead of the NDC's legal team, and also Justice Abdullahi, private legal practitioner, and Jonathan Asante, who is also a political analyst, analyzing what's going on with the court, the ruling that just came out on Judge Kwesi not to hold himself as a member of parliament. Mr. Amaliba, let me come to you to wrap. No, I'll wrap up with you lastly. Okay, then let me go to Justice Abdullahi. Justice Abdullahi, are you there? Hello, Justice. Hello, Lawyer Abdullahi, can you hear me? Okay, so I'm not hearing from Abdullah, but let me go to Jonathan. So, Jonathan, when you were talking, you made mention of how the NDC is consistently losing cases in court. But does it really matter how many times you're losing cases in court? It might be, clearly a technical issue because you have to put up a defense in court. And if you're not able to do that and you lose, that should not be the fault of either the courts or even the party that took you to court.
When the thing is becoming too consistent, then I think that it is no longer a fluke. It is also a little difficult to say that some people have planned to work against the NDC or the interests of the NDC. It's equally very difficult to come out with such a conclusion. But the consistency in terms of the cases that are sent and looking at the similitude, as it were, of certain cases and the ruling is different, it creates problems. As I said, if it is commonsensical to suggest that Techiman South needs representation, though they are in court, then what is so different from that of the Assin North? It is about representation. Nobody has been killed, nobody is died. Even in Techiman South, don't forget, about died out of that particular issue. So, and even we are yet to look at particular, we are yet to conduct investigation. When the two security couples went to the vetting committee, they said that investigation has commenced and that they will bring whatever. Up to now, where is that information? So you see, it creates this kind of doubt, and as I said, it fuels the perception of bias. You see, when that perception is there, and people feel that they will not get justice when they come to the court, they will take the law into their own hands. And as I said, when it happens, all of us will suffer, including the judiciary, including the executive, including parliament, including ordinary citizens of this country. We will all suffer. And I cite an example of 80 BC in Rome, as it were. So when constantly people are being deprived, when constantly people think that others are using aggrandizement to their own advantage, others are being denied the basic necessities of life, that is a recipe for chaos. And if the judiciary, which is at the hub, which occupies the topmost, the centrality of our democracy, as it were, because that is where we seek redress. And every now and then, the situation seems to be tilting towards a particular direction. Yet we all have a cause to be worried. We all have a cause.
All right, let me read a few messages. Jonathan Lasanti, thank you for your time. But someone says that the Supreme Court is gradually taking Ama Ghana to the slaughterhouse. And Kwekunyako, NPP government led by President Nadu is destroying the country. Exactly what their own Kandapa had spoken about some few days ago. Adamu Sakande died in jail because of this same issue. What do you say to that? Well, I don't have anything to say to it. And this one also says, good afternoon. Watching you live from Nkwanta Oti region. My name is Masawudu Hamza, J.R. Capello. In fact, the ruling from the Supreme Court is clearly selective of justice because similar issues came up from Hohoi when some people tried to stop Peter Amewu from going to the parliament, but the Supreme Court said the people of the Hohoi cannot be denied representative. So why Assin North? Stiff-necked obstinacy about very petty things is what this Assin North case is all about. Certainly, it makes it easier for everyone to read politics into what's going on. This is Eric from Kumasi. If people can use legal tactics in the courts to get what they didn't get from voters, then what's the use of the voting? Joe from Tema sent that in. If my government is blaming the economic problems that we are facing as a result of COVID, why is it that the Supreme Court refused to accept the delay of the responses from the Canada as a result of COVID? Nana is asking that from Oda. Once upon a time, the NPP went through the same and eventually said the MP died shortly after serving his sentence. Is it going to happen again? You're asking, democracy is not good for us, Mark Paradise Okocha. One of Muhammad's tasks upon assumption is to clean up the judiciary. Good afternoon. Well, be careful when you're using clean up the judiciary. Okay, so let me speak with Abdullah, Lawyer Abdullah, to just finalize the issue. Lawyer Abdullah, thank you for joining us once again. What will be your final words? When are we expected to go to court again? And how should the two parties involved, hold themselves up going forward? Hello, lawyer. Unmute your mic. Okay. I cannot really hear Lawyer Abdullah, so let me just wrap up because this one says the Supreme Court has spoken. Let's all respect the ruling and move on. Augustine Bini, Kwanzaa from Takrade. And then this one also says that from Anthony. Okay, I've already read this. All right. I couldn't get Lawyer Abdullah, but this is what time will allow us. My name is Ania Frampofu. Let's see how the parties go through the legal battle going forward. Let's also, we'll give you updates of what the substantive case will be.